The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon. Thank you for joining us today. My name is Matt Blottmacher with Peak Trust Company, formerly Alaska Trust Company. For those of you that don't know, we're a full-service provider of fiduciary services. And today we have Alan Gassman with Gassman, Crotty, and DiNicolo. He is very renowned across the nation for his expertise in estate planning, tax planning. He's authored more than 200 articles, performed on numerous webinars, and we are thrilled to have him with us today. He's going to talk to us about asset protection planning, specifically for physicians. And again, very pleased and proud to have him join us. And I'll turn it over to Alan.
Thank you very much, Matt. So in the next 59 and a half minutes, we are going to give you a lot of ammunition that you can use and take to help your physician clients and other professionals who you represent. And I've been representing physicians now for 38 years. They've been more than half of my practice. They're not always easy, but they are usually logical. And as you probably know, you only have a minute or two to get to where you need to be to communicate to have them go forward. They are really fast learners, and that's why a lot of these slides that you see are going to be very helpful. And doctors are clearly different. They're clearly different. Their problems are different. Their intellect is different. And their earning stream can be wonderful. Their asset base can be wonderful. Or it can be terrible based upon whether they get good advice or not. So the good news is they really need you. They don't always know they need you, but they do need you. I want to thank Matt and everybody at Peak Trust Company for allowing me to give this presentation. Peak Trust Company is without a doubt the most sophisticated and the most mobile and responsive trust company in the United States. If you're dealing with tax lawyers or CPAs who really know a lot of tax law, you just tell them you're dealing with Peak Trust Company, which is involved with the Blottmacher family, and they'll say, yes, I know Jonathan Blottmacher, I know about Matt, I'm glad you're working with Peak Trust Company. It makes a real difference for professionals. Some resources for you on pages 2 and 3. I've just given you a checklist of a lot of different asset protection items. Asset protection is often much different than what people think it is, and there's more things that meet the eye than what people normally think of. So after this presentation, I invite you to print these out. If you need them in another format like Excel or something like that, just let me know. I'll be glad to send them to you. You have my email address at the bottom left-hand side of each pages. Anything you need, let me know. Any questions, comments, or suggestions, let me know. Page 4 begins a checklist for CPAs. Are you involving the CPA? The CPA is doing financial statements. The CPA is doing tax returns. The CPA is giving advice. And are you plugged in with the CPA? And is the CPA plugged in with you? CPAs are more and more thinking of themselves as only being tax return and financial statement preparers, which is a pretty lonely life. So if you can bring the client to their office, strike up a relationship, and get the CPA on an annual review for creditor protection purposes, there's plenty of work that they can do and bill for, and they may be forever grateful to you. Page 7 I include because whenever I speak to a group of physicians, I show them page 7, and my topic is almost always creditor protection. And at the end of my presentation, believe it or not, most of the calls and the emails I get are from number 1. And the biggest question they ask me is, do I have enough to retire? Am I heading the right way to retire? How much will I need to retire? And of course, my answer is, don't ask me, I'm an asset protection lawyer. But if you don't know those answers, you need to get good financial advice. And by the way, based on what I see here, I don't really think it's enough Do you really need the 2 vacation homes and the boat before you've got enough to retire on? And they do listen to that type of conversation. And that's what they need to hear from you, I think. You need to ask them the question, do you have enough to retire? Do you know what it takes to retire? And is it saved in a way that is going to be creditor protected? But from items 1 through 12, and you can show this to your clients, you want to ask if they have all these things done. And number 11 is probably the most important. Do they have a good CPA? Do they know where they are financially? You need somebody you can work with. Do they have a lawyer who understands how this works? That's not as important as the CPA. Are they enjoying their professional career? And if not, what would it take to help them enjoy their professional career? You know, I'm in it, you're in it, the CPA is in it for more than just our jobs. We're trying to help doctors enjoy their career more, make more money, save more money, have more fulfilling lives. They will appreciate it. Page 8, I talk to a lot of residents and first-year surgeons and fellows, and I tell them a few things. You can show them this slide. They get a kick out of it. Banks will loan you more money than you can repay. They certainly don't care whether you're going to be able to send your children to college or retire. They just want to know that they'll get paid back on their loan. So when the bank approves the big loan for the vacation home and the 10,000 square foot home and the Jaguar and the Porsche, make sure your doctors understand that doesn't mean that they should borrow that amount. They need to concentrate on saving for retirement so that they don't have to be slaves to a system that they may not enjoy or control in the future. You keep beating that drum and you will have their full attention. Now, talk to them about the process. Doctors understand processes because they have protocols. If you get a particular kind of illness, the doctor knows that he's got to follow the protocol. Please explain to them there's a protocol for this. First, we need all your information and all your documents, eventually at least. Then we need to know what the best strategy is. I need to confer with an estate planning lawyer who understands creditor protection. I may need to talk to your CPA to bring a plan together. Then you need to talk to these professionals. Then they draft documents. Then you review them. Then you sign them. Then you can die. Not until then. So again, they will understand the protocol. Don't spend more than 30 seconds telling them that there is a protocol, but let them know that there is one and that you can handle it and that they need a team of advisors. My most successful financial planning clients and friends well understand and educate their clients that, hey, I'm a CFP and I used to be a CPA. I can't do it all. I'm not a property casualty agent. I'm not an asset protection lawyer. I'm not an estate tax specialist, but I can make sure we bring those people together and use them efficiently and effectively. Because you can be the quarterback of that team, and as your clients grow, the bigger clients are looking for the quarterback. They're not looking for somebody who's going to play every position on the football team. Do you have a good CPA? Again, I said, I think that's a big, big problem for a lot of successful physicians. They don't even realize what a CPA is. They don't know the difference between a CPA and an enrolled agent. So you can help them with that. I have had to see a lot of physician clients go through bankruptcy over my career. Less than half of that was a result of malpractice. More of it was the result of bad business deals gone wrong, automobile accidents, and crazy stuff. And crazy stuff is almost always because they get involved with crazy people. So it's not a bad idea to let doctors know when you guarantee a note, oh, you're in that real estate deal? That's interesting. Did you guarantee the note? Oh, you did? How much is the debt? $10 million? How much is the property worth? $11 million? What do you think the property is going to be worth when the virus freeze is over? Do you think you might have exposure? Oh, you didn't realize what a joint and several liability was? So walking them through this, hazardous waste, would anyone on this call ever buy a commercial building and put it in their personal names knowing that they may have to spend $1 bazillion to clean it up? Doctors don't realize that. They don't understand why you would put real estate into an LLC to block liability in case there's asbestos in the building, or in case somebody walks into that building, has an asthma attack, and dies. You wouldn't want to own that building directly, and you'd want to have a lot of insurance, but you guys know insurance doesn't cover everything. So I've seen clients with all sorts of problems with all these different types of liability. Go through it with the clients. I've got a Forbes article. You can just Google Gassman Forbes driveway. You can share this article. Your biggest financial nightmare is parked in your driveway. I've had a number of doctors lose significant assets because of automobile accidents, not even when the doctor's driving, but when he lets somebody drive her car. Now, page 18. On the left-hand side, you have the liabilities that don't go away. We're going to mention the wonderful phenomenon of bankruptcy, which enables most doctors on a malpractice claim or a bad business loan or a car accident to file bankruptcy, get rid of the judgment, and keep their creditor-protected assets. That doesn't apply to student loans. That doesn't apply if they don't pay the right taxes that they withheld from their employees' paychecks. That doesn't apply to hazardous waste liability if they were active in making the waste. It doesn't apply if they were the trustee of a trust and they borrowed money and couldn't put it back. It doesn't get rid of child support and alimony. It doesn't get rid of penalties to Medicare or the government or restitution for criminal acts. When they have these issues, you need to get them to the right lawyers, and you need to tell them to pay these things first. And if you're friendly with them, tell them not to wreck their marriage. Child support and alimony and lawyer fees on divorces are horrific. And how many clients have come to me and said, oh my gosh, I'm so glad I got divorced. My next spouse is so much better than the first spouse. They don't tell me that. They just tell me how expensive the prior spouse is. So get along with your spouse, especially if you're having to be in quarantine with your spouse. Get along. Do what they say to do. Now, on the right-hand side are things not covered by insurance. The first thing everybody thought when this virus started was, oh, good, I can finally use my business interruption insurance. Oops, sorry, you can't. It doesn't apply for most people. Oh, my gosh, I was on the synagogue board, and we wrote a nasty letter to somebody, and they're suing us for $1 zillion. I'm sure that my homeowner's policy and my umbrella will cover that, right? Wrong. Oh my gosh, a doctor working for me sexually assaulted a patient. I'm sure we have insurance for that, right? No, wrong. It was an illegal act. You don't have insurance. I have a $5 million umbrella. My son killed someone with a jet ski. I'm sure I'm covered. No, sorry. Jet skis are only covered up to $250. So make sure clients understand it's good to have insurance, but sometimes not good enough. And then there's the super creditors. Now, I'm not talking about Batman and Robin. They would be even worse. But when you owe money to the IRS, the FTC, the SEC, Medicare for penalties and fines, or you're in family law, a lot of the creditor protection I'm going to talk about simply doesn't work. If I set up an asset protection trust with Peak Trust, it's properly drafted, properly funded, well before I ever would even think of having an IRS problem. And then I have an IRS problem. The IRS cannot reach into an asset protection trust. In fact, there was a case last year, the Campbell case, where a tax court judge held that an offer in compromise had to recognize that the IRS had no access to a properly drafted creditor protection trust that was set up before there was a problem. But on the other hand, here I am in Florida. I have my homestead, I have my IRAs, I have my pension account, I have tenancy by the entireties with my wife. Those items can't be touched by creditors, oops, except for the super creditors. So the IRS can come and take all those things. They can't reach into certain other things. So what works against the super creditors? And by the way, it is usually a federal crime to take assets and move them for the purpose of avoiding a super creditor or helping somebody do that. So this needs to be done well before a super creditor arrives at the scene. Charging order protection, which we're going to talk about, will work against a super creditor based upon the case law thus far. Asset protection trusts. Foreign trusts protected by foreign laws may help. Assets that the debtor already gave away. So again, it's every doctor's dream, nightmare, that the IRS or Medicare shows up and says, we're sorry, it was done all wrong. You owe us millions of dollars. Pay us now. Leave your house. So you want to hedge your bets. You don't want to put all your eggs in any one basket. And of course, don't forget Murphy's Law. So I'm going to take you now through some asset protection definitions. These are important concepts that we want you to be conversant on for when you talk with creditor protection lawyers and trust companies, etc., and also to help explain how these rules work. The exempt asset is an asset that is protected under creditor law. So even if you get a judgment against me, I live in Florida, you can't touch my homestead, you can't touch my IRA, you can't touch my 529 plan. Those are exempt assets. I can file a bankruptcy and get rid of business debt and tort debt without losing my exempt assets. Non-exempt assets, obviously, those are all the other assets that a creditor can reach. A fraudulent transfer. Now, that has nothing to do with committing fraud. When you commit fraud, you cheat someone, you're dishonest, you fool them. A fraudulent transfer is a transfer that somebody makes to avoid a creditor. If you have a known creditor and you take your assets and you move them from non-exempt into exempt, then you may have committed a fraudulent transfer. In some states, like Connecticut and California, that can be illegal and it can get anyone who helps you into big trouble. But in other states, most notably to me, Florida, where I practice, you can make a transfer to avoid a creditor intentionally, and it is not against the law. Some people think it's unethical. Some people think it's very ethical to protect your family against a creditor who might treat you unfairly. So that is a fraudulent transfer. In many states, they're changing the definition to call it a voidable transfer. And in many states, the only consequence is that the creditor may be able to set it aside over a fight. But don't get involved with recommending transfers to avoid creditors unless you're very careful and you understand what rules can apply. Now, a charging order. A charging order is an order from the court when I own 95% of a limited liability company and Matt or Peak Trust Company own 5% of that limited liability company, and a creditor gets a judgment against me. Under the laws of most states, not all, but most states, the creditor who has a charging order, who has a judgment against me, cannot reach into my LLC if there's another legitimate member. The creditor is limited to getting what is called a charging order, and the charging order says, Dear Alan, dear LLC, if and when there will ever be a distribution to Alan, give it to the creditor. They have a lien on Alan's interest, but the creditor can't reach into the LLC. They can't get anything out of the LLC. We are at a stalemate. I can't get anything out. They can't get anything out. Plaintiff lawyers don't like that. Plaintiff lawyers want money now. They need money now. Their clients need money now. The last thing a plaintiff lawyer wants is a client to call her every 3 months for the rest of her career saying, when's Alan going to take something out of the LLC? Take his deposition again. What can you do? How can I get my money? So most of these matters settle. Some states have have charging order protection even if the debtor owns 100% of the LLC. Now, if I am going to have an LLC with my savings in it, and I am going to, I'm going to use a creditor protection trust to hold that LLC. But I'm a little concerned the judge may not like the creditor protection trust, or I may be doing this a little bit too late. So why not take that LLC and have somebody invest a few $100,000 or some money into it, or set aside a little bit of a percentage of ownership of that LLC to a trust for my cute little children or grandchildren. Then I own, say, 96% of the LLC. I give that to the trust company. Now, even if the creditor can set the trust aside, they're only going to get a charging order. So it's really good to have clients own LLCs and limited partnerships and to have other owners. And of course, as you know, that's also beneficial for estate tax planning and sometimes for income tax planning. So just think about that. Now, page 24, a secured interest. This is like a mortgage. If you're a doctor and you have furniture and equipment in your medical practice that you don't want to lose in the event of a lawsuit, you want to give a friendly creditor what we call a security interest in those assets that are in the medical practice, so that even if the plaintiff lawyer gets a judgment, the creditor is going to come in, call the loan in, repossess everything, sell it to the doctor's spouse or best friend, and all the money goes to the creditor. There's nothing left there for the plaintiff lawyer. So that is the secured interest. Bad Faith, page 24, that's not a rock band that Eric Clapton was in. That was Blind Faith that he was in. You know that. Bad Faith is when an insurance carrier has an obligation to pay a claim and doesn't pay it. What you need to know is that in most states, when a doctor gets an offer to settle a malpractice claim within policy limits, when he tells the carrier, I demand that you settle this claim within policy limits, you have the opportunity to do so. The carrier says, no, we're going to defend this. We win 6 out of 7 claims. They go to court. The verdict comes in above policy limits. Now that's the carrier's problem, not the client's problem, if there was demand made to settle. So your clients who are in horrendous liability suits, they need to have not only the lawyer hired by the malpractice carrier, but also an independent lawyer who can write a demand letter. Oftentimes, I will reach out to the plaintiff lawyer, say, Floyd, I know you're trying to get more money, but the client only has a $500,000 policy. Give me a letter offering to settle within policy limits. I'll write a letter to the insurance carrier demanding that they settle. Then if they don't settle and you get a multi-million-dollar verdict, you're going to get more money from the insurance carrier and my client will be safe. So when you have clients who confide in you that they have a lawsuit situation, don't forget about the bad faith situation. Automobile liability here on page 25 is good. The best book most doctors could ever read, How to Stop Worrying and Start Living by Dale Carnegie. They lose a lot of sleep over these lawsuits. His book is just excellent. And if you will read his book and explain these principles to your clients, they will be forever, forever grateful. I'm not going to go into what these principles are, but especially at a time like this, people are worried. Carnegie had really good techniques for handling that worry. I hand out at least 30 to 40 copies of this book every year, and I get so many thank you notes and emails. Thanks very much for telling me about this book. It's ageless and timeless. Okay, it was not raining when Noah built the ark. Obviously, you want to do this sooner rather than later. If you don't, then you may have to look at a chart like this, which says that under state law, these transfers can be set aside, and who you give the assets to may get sued to make them have to give them back. Page 28, most physicians don't understand umbrella liability insurance, so I've got a chart here that you can use to explain it to them. I don't know about you, but I normally will write a letter to the P&C agent explaining the situation to them and asking them to confirm that there's proper coverage. In Clearwater, Florida, the agents call it the Gassman letter. When they get the letter, they're always a little bit upset because I wrote them a letter, and they usually call me and go, I'm sorry, I didn't know there was a four-wheeler, didn't know that they parked the car at the vacation home, didn't know they had a son-in-law who's driving the pickup truck. Thanks for letting me know. I'm going to adjust the coverages. Clients will appreciate that. I've given you a sample of the letter here. Page 31, again, the P&C stuff. They don't know about these things, so it's a good idea to tell them about it. Malpractice insurance, they don't understand that either. You can read about the malpractice insurance. By the way, I have a book called The Florida Physician's Guide to Creditor Protection that explains a lot of this very, very thoroughly. I'll be glad to send you a free PDF of that book if you just send me an email. If you're not in Florida, it still can be very helpful. On the malpractice insurance side of things, look at this. Look at these rates, for example. You're a dermatologist. You can get $250,000 coverage for $4,000, or $1 million coverage for $6,000. You make $1 million a year. You explain to your CPA that you really can't afford the extra $2,700. It seems like a lot of money. I think we have to tell the clients, you will sleep much better with $1 million coverage. The client will then say, yeah, but I heard they almost always settle for your policy limits. Just Google doctor, verdict, jury, 2020, and watch what comes up. Several multi-million-dollar verdicts. You can show the newspaper clippings to your clients. Say, no, they don't always settle for policy limits. Look what happened here. So I'm in favor of the higher policy limits. Again, our time is short, but I've given you discussion on pages 35 and 36 on advantages and disadvantages of policy limits. Some other things we can do for clients, they really like to hear these things, so you can tell them in case it's of interest. My 45-second rule on page 4, whenever you're with a patient, spend 45 seconds thinking about what can go wrong? How might I get sued? What do I need to do about it? Sometimes that's chart note, told Mrs. Smith to make sure she took the antibiotic every day until the bottle was full, told the nurse to call her on day 5 and make sure she knew to take it every day till the bottle was done. Told Mr. Jones not to mow the lawn anymore, put it in my chart note, don't mow the lawn anymore. Here's an important one. Called in 3 specialists to manage this patient with me so that this patient has the best care. Put her in the hospital so she has the best care. By the way, if anything goes wrong, they're going to sue all of us and not only me. Had the nurse practitioner see the patient the week later. Now they're going to sue not only me, but also the nurse practitioner. The nurse practitioner has separate limits. Went and visited my friend, another doctor in the hospital. We have a lot of patients together. His chart notes are terrible. His follow-up is terrible. I read him the riot act. I told him I'm not going to manage cases with him until he gets his act together. Those are all the things that they're going through, that they're thinking through, that you can help them with. Page 39, make it very clear to your clients what is creditor protected and what is not. This chart for page 39 is the Florida creditor protection chart. Let me spend 1 minute on Florida. I'm biased towards Florida. Here's where I am. But we have 2 really nice things in Florida which make it a reason for somebody to move here besides avoiding taxes and being in a warm place. One is that our Supreme Court has ruled in a unanimous decision, that when you buy a homestead or pay a mortgage on a homestead for the express purpose of avoiding a creditor, the creditor cannot set it aside because our Constitution says that. Our fraudulent transfer statute is not in the Constitution. Homestead protection is. So one trumps the other, and that's why Trump moved here maybe. Probably more likely it was tax avoidance. But secondly, in Florida, it is not illegal and it is not something that is punishable to make a transfer to avoid creditors. It may simply be set aside if the transfer is made to something other than homestead within 4 years before the creditor attacks it. And then we have unlimited protection for homestead, for IRAs, for 401ks, for cash value life insurance, for annuity contracts, for the wages of the head of household, all unlimited, and for tenancy by the entireties. So if I own an account jointly with my spouse, it's got $1 million in it, you get a judgment against me, you don't have a judgment against my spouse, you can't touch the tenancy by the entireties asset, I can file a Chapter 7 bankruptcy, the judgment goes away, and I keep all of these assets. Now here is your estate planning schematic, and I do hope, I know I'm going fairly quickly, but I do hope that you're jotting down client names, referral source names, and charts that you'll use later with your clients, because you are welcome to use these charts. You can even take our name out from the bottom. If you got this chart from Peak Trust Company, you can use it. So here's a client's revocable trust, her spouse's revocable trust, their TBE assets, an irrevocable trust for descendants, and a SLAT, a lifetime bypass trust. Spouse 1 should not own any assets if she's a neurosurgeon. Maybe they're in tenancy by the entireties, but then if spouse 2 dies, spouse 1 loses those TBE assets. Maybe we put a lot of life insurance on spouse 2 payable to her trust or to a life insurance trust. So if spouse 2 dies and you lose the creditor protection of the TBE assets, you have a funded credit shelter trust for the health, education, and maintenance of spouse 1 that is never subject to creditor claims. Have you read their trusts? Have you confirmed that the trustee is not required to give the surviving spouse 5% of the assets each year, because the creditors could touch 5% a year? Is not required to pay the income every year because the creditors could take the income? Is there a trust for children? Are they funding education in a 529 plan if that's creditor protected? Or better yet, in an irrevocable trust for the children that could own the 529 plans? Spouse 1 can fund a trust for spouse 2 and the descendants. I call it a lifetime bypass trust. You can call it a spousal limited access trust. That trust could even benefit spouse 1 if it is in an asset protection trust jurisdiction, and if it is properly designed and implemented. Your friends at Peak Trust can tell you how to do that. So these are all good estate tax planning maneuvers and also very good creditor protection maneuvers. And let's look at slide 41. It's the same thing again, but we show the tiers below. So not only would they own their assets as tenants by the entireties, but they could own them in a limited liability company or a limited partnership, which is owned 3% by the trust for children. So even if somebody gets a judgment against both spouses or one of them dies, you're not going to have anything but a charging order protection, not complete loss. And if spouse 1 is a control freak, and who isn't, and they want to put a lot of assets under the spousal limited access trust, it could own an LLC that they could control. And of course, the gifting trust for children, if it is set up in an asset protection jurisdiction in a proper way, and spouse 1 and spouse 2 become destitute, then they could get access to that gifting trust, but it may still be completely creditor protected. So again, great things going on here. Page 42, you could call that spousal access trust a Dynasty trust. This is something that you can share with your clients. Page 43, we give all of our clients a schematic like you see here, which explains what they have there at the top, what they own is below what they have, and then we show them, here's what you have now, here's what's exposed, here's not what's exposed, and here's what we would like to do. We'd like to make sure that your joint assets are in tenancy by the entireties. We'd like to make sure that the non-physician spouse gets plenty of life insurance, payable to a trust for her for the benefit of the doctor and the children. That's going to save those life insurance proceeds from the creditors of the doctor and from the next spouse of the doctor. We want that non-physician spouse to own an LLC, 97%, 95%, 97%. The gifting trust for the children can own 3 or 4%. We want the medical practice divided up. We don't want the medical practice to own the MRI machine, the CT machine, all the furniture, all the equipment, all the accounts receivable. That's crazy. Put that against it, and then put the medical practice entity separate from the equipment entity, separate from the intellectual property, separate from the vehicle. When the doctor gets in a car wreck, we don't want to lose all the assets of the medical practice because he had the car in the name of the medical practice. So again, I'm going too fast, but hopefully I'm keeping you awake. And we want you to show the clients what they have now, show them what they can have when they're done, and you will be amazed at the success rate. You may be auditory. A lot of really good financial advisors are auditory. Auditory takes longer to explain. Doctors have a very short attention span and a very high propensity for ADD. A picture they will look at, a circle they will look at. If you show them this chart before and after, and you can explain it in 2 minutes, they will look at you and say, wait a minute, just get it done. What else is new? So try that. It takes a lot of time to draw this out, to talk to a good lawyer or financial planner, to talk to a trust company. Floyd, here's what you have now. Here's what I think you want to have. If you want, I can make it happen. Do you want me to make it happen? And by the way, there's life insurance involved. There's financial products involved. Do you mind if I get that handled also? And you'll be surprised how often the answer is yes. Stop boring me with the details. Get it done. You can use this to explain how the first dying spouse will have a credit shelter trust and a Q-tip trust, and the surviving spouse will have GST. And here's the life insurance. Use these visual cues. More of the physicians are visual than they are auditory, and even the auditory physicians are really fast learners and much likely to listen better if they have the visual cues. Now, when you're with the spouse, say, hey, you know, when you die, do you want all these assets to go to the doctor's next spouse? And the answer will be, of course not. I want it to go to my children. So when you have joint with right of survivorship, or you have a lot of assets in the name of the spouse who may be the survivor, they may want to sign a marital asset preservation agreement, where the agreement says, if one of us dies, the survivor will fund an asset protection trust to protect the assets for the surviving spouse and the descendants. And this means that when I die, my wife has to fund this trust. It's not funded to avoid creditors. Even though there might be a creditor, that's not the reason it's being funded. It's being funded because she is legally obligated to do that to save our assets from the next spouse that she may marry. So this marital asset preservation system, mention it and watch the eyes of your clients when you say, by the way, when one of you dies, it's not all protected. The surviving spouse could give it to the next spouse. Is that okay? No, it's not okay. Get us to a lawyer. Get that fixed. Page 48, another chart you can use. Here's the doctor. The doctor's single. Here's what the doctor can own that's creditor protected. There's the automobile. Insure the heck out of it. There's the homestead. There's the revocable trust. The revocable trust doesn't save anything from creditors. The doctors all think it does. Go to 6 doctors and say, does your revocable trust save things from creditors? The doctor will go, yeah, I think it does. No, it doesn't. Let them know that. Don't put anything in the trust if you can instead put it in safer places. But this doctor has a professional corporation. This doctor has an equipment company that owns the equipment that his professional corporation leases. He has long-term leases. He has a lot of debt against the company. He has his securities portfolio in a limited partnership owned partly by his living trust, partly by his gifting trust, so that he has charging order protection, or he may have some of this in a creditor protection trust. 95% of the creditor protection trusts that our law firm draws are domestic. 5% are foreign. We give the client a choice. The foreign is much more expensive. The foreign has more tax risks. The foreign is more cumbersome. When the client wants to know the difference between foreign and domestic, we do explain that our domestic trusts can require that if there's a lawsuit against the doctor, the domestic asset protection trustee is required to move the trust to another jurisdiction. And then often, if things are really hot and problematic, that jurisdiction can be a foreign jurisdiction. So by the time there would ever be a judgment, years after that, you would have just as much protection if you started with a domestic trust as if you ended up foreign. In fact, the laws of a lot of these foreign jurisdictions say if you started this in a domestic jurisdiction and you move it to foreign at the last minute, the foreign jurisdiction will still treat that trust as having been started when it was started in the domestic jurisdiction. So just a little banter there for you. Some clients will buy houses for their children in college or graduate school. Put that in an irrevocable trust so that the child's creditors can't reach it. You can make it what we call a Section 678 trust, so it's considered as owned by the child for income tax purposes. So when the house is sold, the $250,000 exclusion from capital gains applies. You can still make the client's spouse the beneficiary of this trust. When the child doesn't behave, you get it right back. Here's some slides you can use to explain asset protection trusts, which are very good vehicles. Not my job to go through them today. Talk to your clients about getting their parents' estates planned. Their parents can be good clients for you. Here's a recommendation that the lawyer will enjoy. When you say, hey, Floyd, we've been talking for 5 years about getting your parents' estate planned. We don't want the inheritance to come to you, or you may lose it in a malpractice claim or to divorce. Floyd says, well, I keep telling my parents, I keep telling their lawyer, I can't get anything done. All right. I will have your lawyer, Floyd's lawyer, draft an irrevocable trust. The irrevocable trust will have Floyd as trustee. It will be funded by the parents when they die. It'll have all the right stuff in it. The parents only have to amend one sentence of their estate plan, of their will and trust, to say the disposition for my son Floyd will instead go to the Floyd Jones Trust dated January 1st, 2021. Now when the parents die, Floyd is the trustee. It is creditor proof because it's for Floyd's health, education, and maintenance, but funded by Floyd's parents. It wouldn't work to go to Floyd's revocable trust, but again, this is another bag in your bag of tricks, or arrow in your quiver, hand grenade in your weaponry case, whatever you want to call it. That is the inheritance trust. A lot of your physicians need to have an inheritance trust to safeguard their inheritance. Okay, we spoke about charging order protection. Many states don't recognize charging order protection, so you may set up the LLC in Nevada or in Alaska or a state that has creditor charging order protection. Then there's a good chance that it will apply, even though it may not apply in the state where the client resides. That's not for sure because of the conflict of law rules can be very confusing and cumbersome. Now, do me one favor. Don't let clients sign or create LLC operating agreements that come from the internet or LegalZoom or from their accountant. They are often done wrong. Now, LegalZoom probably has good forms, but the form is only as good as the answers that you use to answer the questions on the forms. The operating agreement of an LLC can cause loss of tenancy by the entirety's protection, can cause loss of the S election, can cause loss of charging order protection, can cause all kinds of problems. I am particularly wary of accountants who provide charging LLC agreements. I think it is naive and ill-advised. I once had dinner. I sat next to a lawyer who does a lot of trust work for people who aren't that wealthy. He said, "Alan, I really like your irrevocable trust form. I use it on all my irrevocable trusts." I said, "Well, which form?" He said, "What do you mean?" I said, "Well, I have one form for a gifting trust that's for joint, one form for single, one form for a life insurance trust, one form if it's GST exempt, one form if it's not GST exempt, one form if it's a slat, one form if it's a domestic slat. So which form are you using and for what for?" And he changed the subject. So please be careful out there. Use competent advisors, preferably lawyers who have AV rating in martindale.com, and have clients pay and get the operating agreement reviewed or fixed. Now, page 66. When you're advising clients who have family limited partnerships, family LLCs, don't put all the eggs in one basket. I've seen all these problems. So you have this client and they have $5 million worth of mortgages that are owed to them. They've got $5 million invested with their friend Harry and his hedge fund. They've got an LLC interest that they invested in. And of course, what happens? Well, number one, it turns out they weren't following the Dodd-Frank law. They get sued for $1 million. All their assets are exposed. Number two, the best friend turns out to be Bernie Madoff. Not only did they lose their investment, but they're getting clawback lawsuits from the bankruptcy court, which happened to so many people in the Madoff case and in other cases, the Nadler case, the Perling case. Number three, it turns out the operating agreement for the real estate deal with their friends had a capital call provision. It had a bank guarantee provision. So a separate LLC for each type of investment that could go belly up. And tell them if they're in a hedge fund with their friend and he's always doing good. In fact, he even did good when the virus happened and the market dropped so bad. Watch out. There's a lot of Ponzi schemes out there. There's a lot of people who have a propensity when they lose clients' money, they hide it. They're able to, and they do. So do be careful. Page 67, another possible hot button for your clients would be confidentiality. Would they like their home held in a land trust where the trustee is a company, an out-of-state company, so that nobody can easily find where they live in the property records? Do they want to have that same out-of-state company be the manager of their various investment LLCs and family limited partnerships so that it's not easy to track them down? Confidentiality is something that can be near and dear to the hearts of many doctors. Page 68. This is an example of an arrangement that you can recommend for clients. here we had a lawyer. He has a legal practice. He's in a high-risk legal practice strategy. He had a building when he came to see me, free and clear. Then the love of his life was not his ex-wife. It was his horse property. He had beautiful, beautiful horse property with stables that he was renting out to his friends. They had their thoroughbred horses there. Well, I formed a irrevocable trust in Nevada. I made a Nevada trust company like Peak Trust Company, the trustee. I formed a Nevada LLC. I also formed a Florida irrevocable trust for his children. I have 3% of the LLC owned by that Florida irrevocable trust. It has half of the voting rights and 2.5% non-voting. I have the client with 0.5% voting. I have the trust company with 96.5% non-voting. The Nevada LLC owns an LLC that I set up, which owns the office building. That LLC owes money to the Nevada LLC. The Nevada LLC can have a mortgage on the rental property. That note is owed by the real estate LLC, but guaranteed by the medical practice. So it's a $1 million building with a $900,000 note. The medical practice owes 20 years rent to the real estate LLC on a 20-year lease. The medical practice goes bankrupt. 20 years rent is due to the LLC. The LLC has a UCC filed of public record. And at that point, ABC Nevada LLC swoops into the practice, repossesses its accounts receivable, furniture, and equipment, uses that to satisfy the $900,000 real estate loan. Nothing there for the personal injury lawyer. This may or may not work, depending upon your situation, but this will dissuade the vast majority of personal injury lawyers from having any expectation of getting anything beyond policy limits if there are no assets exposed. What did I do for the horse ranch? I put the horse ranch in a separate LLC. That LLC also owes a note to the Nevada LLC. That LLC did a triple net master lease of the property to the stable company. The stable company owns the barn and owns the stables. The stable company operates them. By the law of Florida, a creditor, somebody who gets hurt on the property, cannot pierce the triple net lease. Even if they could, they're dealing with property that is highly leveraged. So these are all things. This is the schematic I showed the client. This is what I want to do. What did he say? Did he say, explain it to me? Nope. He said, do it. Then I explained it to him, even though he didn't care. Maybe, well, actually, he did care. I'm joshing. This particular client was very conscientious. He did care. And he did let me go forward and let me do this because he saw it. So show your clients. Page 69, if you have clients with highly leveraged real estate and you're not sure whether it may go upside down and they may have to negotiate for debt forgiveness, send me an email to ask me about the CREST technique, C-R-E-S-T. They may want to convert that LLC to an S corporation or be able to convert it to an S corporation to avoid some big problems that could occur. So I have a lot about Florida Homestead. One thing I have that may tickle you is everybody thinks that their home was a great investment. We all know their home was probably the worst investment, not nearly as good as their stock and bond portfolio. I have an article here beginning at page 73 that you can use to explain that to your clients. The median house doesn't go up by 3.5% a year. I'm sorry, your house is not the median house. Your house is a year older every year, and you had to fix the roof and replace the air conditioner, et cetera, et cetera. Page 77, I have a lot of information on tenancy by the entireties, but for most of you, that's not very important because you're not in Florida. Page 83, another very useful chart. Show this to the clients. Here's your S corporation. Here's where the money can go. Pension plan, creditor protected, and tax deductible. Put more in. Do cash balance plan. Do defined benefit plan. Children on the payroll so that they can form a Roth IRA. Wages paid to the doctor. Tax deductible, often creditor protected, depending upon state law, if they go directly into another creditor protected vehicle. Dividends, not creditor protected, but avoid payroll taxes. Spouse on the payroll causes payroll taxes. Rent, tax deductible, may be good for creditor protection purposes for the reasons I showed you. Interest owed to a related party, tax deductible, and the related party gets paid before the creditor. I'm going to skip now to page 122. I have a lot of other things here that you can read, of course, how much they can put a year into their defined benefit or defined contribution plan. Get an actuary to show you the numbers. I think everyone on this call knows how outstanding those numbers can be. Did you know that your IRA can own a business? If the doctor wants to set up a business, but he's concerned about creditors taking it, the business can be owned by a Roth-held C corporation. I don't recommend this. In fact, it's very risky from a tax standpoint, but it's out there, so you should know about it. Put more money into the 529 plan. If the 529 plan went down in value, get a new 529 plan. You'll have that much more protection. That's detailed in this article on page 94. I'll be glad to send you a copy if you need it. Life insurance obviously is a wonderful thing. You can use offshore life insurance and use the Hampton technique to avoid the need to even have a mortality expense if it works. I'm trying to find that slide. The slide is missing, I'm sorry, but I'll be glad to send you information on it if you need it. But let's go to page 122 because I want to be on time here. Buy-sell agreements, funding them is good, but my gosh, don't have the medical practice own the policy. Put the policy in a separate LLC, taxed as a partnership, do a cross-purchase agreement using a trustee arrangement as I describe here so that the policy proceeds are not lost to a malpractice claimant. Page 123, the new parent F reorganization. When you get started here, all these assets are in the medical practice, including the building and the equipment. The CPA says you can't move it out, you'll trigger tax. Not quite right. You set up a new parent company. It's also an S corporation. You transfer the medical practice to the new S corporation. It has the same tax ID number. Nothing has to change. Medicare number doesn't have to change. Now the medical practice can do a tax-free transfer of the equipment to one company, the real estate to another company, the car to another company, and the accounts receivable can be purchased by another subsidiary, so the medical practice doesn't even own the accounts receivable anymore. It can enter into a factoring arrangement, sell the accounts receivable periodically once a week to the factoring company. The factoring company can borrow money at a high interest rate from the family limited partnership. One S corporation, 1120S, covers all these activities. The deduction for the amount owed to the family partnership by the factoring company can be significant, moving taxable income from the doctor's return, reducing the doctor's income. Maybe she'll qualify for a 199A deduction. This works well. Page 124, 3 minutes remaining here by my count. Medical practice owned, no debt against it. The medical practice can only owe so much without triggering income tax because the CPA will tell you that the basis of the medical practice is the most that the medical practice can owe the doctor, and usually his basis in the stock is low. The doctor sets up the new parent S corporation and can owe an unlimited amount, have an unlimited amount owed by the medical practice to the S corporation. Page 127, the practice can borrow money from the bank and give that money to the doctors, but then they pay tax on it. It comes out as a dividend. But the bank could loan the money to the doctors individually. They could buy annuities, life insurance, or other protected assets. The medical practice can guarantee the loan and can pledge its assets as collateral for the loan. Now, if there's a malpractice claim against Dr. A, he's insolvent, the practice is insolvent, the bank collects these assets and repays, is made whole. The creditor, the bank takes Dr. A's protected assets to repay the loan. The creditor has nowhere to go, nothing to get. This used to be marketed as what they called the golden handcuffs annuity arrangement. It was very popular. It's still out there. The building loan can be guaranteed by the medical practice. Here's showing you where the bank loans the money to buy the annuity or the life insurance. These are all things that you can think about, that you can talk to your clients about. This is a more explicit explanation of the accounts receivable thing. So we've covered a lot. There's more here. Things that you can review with the client's CPA, with the client's lawyer. Become adept at these items. Ask the people on your advisory team how they work. Share them with clients. Do a great job for people. The doctors will appreciate it. The doctors do appreciate their financial advisors, not only for the financial advice, but also for the personal advice, for the tax advice, for the creditor protection advice, for caring and for being conscientious, for quarterbacking the team, for reminding us of what happens, for reminding the client of what's needed. That's my hour. You've got my email address there. I hope you use it for questions, comments, suggestions. Matt, thank you so much for having me. Thanks especially to Peak Trust Company, to Jonathan Blottmacher, to Brandon Scintilla. If you have questions about anything I've mentioned to you, call Brandon Scintilla at Peak Trust Company. Call Matt. They understand these concepts. They can help explain them. Stay safe, stay healthy, stay successful. Thanks again, Matt.
Alan, thank you again for joining us today. And thank you everyone for participating. And we look forward to seeing you on one of our future webinars.